Hello, my name is Christopher Slitor of Arlington, Virginia. I'm the husband of Nancy Hay, and my nickname is Kit. I'm using these sunshades because they've got diopters built in, so they help me read my speech. My wife and I have been assaulted by a legal and bureaucratic nightmare in Arlington County, Virginia, namely the legalized abduction of our daughter Sabrina by a clique of bureaucrats, anti-social workers, judges, and biased hired gun quasi-professionals acting as self-proclaimed protectors of the best interests of our child. On April 18, 2008, the DC Examiner newspaper wrote an editorial supporting our side of this case. It was aptly entitled "Baby Snatching by Arlington County." They also did two subsequent articles referencing our saga. Email response from the general public went heavily for us. Our legal case involves thousands of pages of documents. My wife, her mother, and I have vainly sought justice in the courts and have spent about $600,000 in legal expenses and over 4 years of litigation. We started in the Juvenile and Family Court, appealed to the Circuit Court, and then to the Court of Appeals in Richmond, Virginia, to no avail. We're even trying to get it into the U.S. Supreme Court. Many of the people listening today already know that the statute's, unquote, child protection, unquote, law are bad to begin with, and furthermore that the administrative family court judges, guardian ad litems, county attorneys, and CPS, which stands for Child Protective Service, interpret the law in the most twisted, biased, and dishonest fashion. There's absolutely no compassion or benefit of a doubt for the defendants. They effectively throw the entire weight of the state at you with no mercy or let-up. In Virginia, juries are not allowed to weigh in on these cases. The accused face a judge, a county's attorney as prosecutor, a guardian ad litem appointed by CPS to represent the interests of your child in the Child Protective Services Agency. Essentially, they act as a team, united in their desire to take your child and put him or her in foster care. There's no proof or assurance that they don't communicate with each other, which is technically illegal, but circumstantial evidence suggests it happens all the time. There are no financial incentives to keep a family together, only to put children into foster care. The CPS system rushes to judgment. In our case, everything they used against us was false or grossly exaggerated and taken out of context. This leads us to another legal point. There are no rules of evidence. The judges never challenge anything the county's attorney or social workers say. Here are a few snapshots from this lengthy and complex case. My wife gave birth to daughter Sabrina, April 2005. Around the second week of her life, our pediatrician, Eli Mushauer, noticed that she lost less than 10% of her weight after birth, which is very common. When the baby failed to gain weight, rather than increasing the formula to supplement my wife's breastfeeding, he recommends taking the baby to Virginia Hospital Center to get control of the situation. After my wife stayed in VHC for 4 days and the baby regained the lost weight, we were prepared to leave the next day. All of a sudden, a CPS social worker comes to investigate. Just like a police state, no one openly communicated any reservations or suspicions. They speculated and talked behind our back, never consulted us, picked up the phone to call CPS, and falsely alleged that my wife was starving our baby. The social worker assigned to investigate our case, Dana Zemke, was incredibly rude and hostile. We were both exhausted and tired, and she stated that our baby would not be allowed to leave the hospital until we signed this agreement to services. There are no Miranda warnings and absolutely no written disclosures as to the consequences. Only later did we find out we were now enslaved to the ironclad demands of CPS. When we requested to have a timeout so that we could consult legal counsel, the county responded by ordering an emergency removal order containing false information, misspelling, and grammatical errors. Both CPS and the juvenile court judge did every dirty trick in the book. We complied 100% with their requirements. The county provided no social services whatsoever, only minimal visitation. When Sabrina started to cry at visits, the county did nothing to resolve the situation. We had to hire our own social work team at our own expense. They stopped Sabrina's crying within a week. The county lied to us, deceived us, and ran out our legal clock. Every court appearance, the county's witnesses got to go first. Our witnesses were often forced to wait until court closed, effectively denying them a chance to get on the record. Every time the statute gave a time limit for legal responses from the county, they either waited until the last minute or waited beyond the deadline with no legal penalty. In Virginia, there is both a legal and administrative track for people accused, and I might say often falsely, of child neglect and abuse. Before our case got to circuit court, a state hearing examiner, George Walton, from the state headquarters of the Department of Human Services, spent an entire day reinvestigating the original accusation of child neglect and abuse. After examining the evidence, he exonerated us, found us innocent, and took both my wife and I off the dreaded state registry of child neglectors and abusers. This dramatic repudiation of Arlington, Virginia CPS failed to sway Arlington County to drop their bogus case against us. In Circuit Court, Arlington, Virginia, Judge James Solomon allowed the foster family to have their lawyer ask questions and cross-examine, which is tantamount to allowing them to become a party of the case, even though that is against the Code of Virginia. And Judge Newman of the Circuit Court previously prohibited this. The judge in the county allowed the foster family to move out of state with our baby just as the trial was starting. After the expert witness list deadline had expired, the county was allowed to sneak in one afterwards, and the judge used this testimony to decide against us. The decision was curt and brief, upholding the county, effectively rubber stamping it word for word. We did appeal to the Court of Appeals in Richmond, Virginia, and unfortunately they ruled against us. Our interpretation is that although we had a very good case, the three-judge panel probably found it politically expedient to circle the wagons and protect Arlington County from embarrassment and possible liability. Although politics and cronyism is not supposed to sway the scales of justice, we know that it does. The foster father just happens to be an assistant prosecutor for the Federal Department of Justice, and his wife is a fundraiser for the dominant political forces of Arlington, Virginia. When the foster father worked in Washington, D.C., I am sure he was a member of the bars of Maryland, Virginia, and D.C. It is quite likely that he knew some of the lawyers, judges, and social workers involved with the Arlington CPS sphere of influence. My wife and I suspect there are many improperly cozy acquaintances between the foster parents and the powerful clique that enabled the legalized kidnapping of our daughter. I will close by urging all victims of CPS to gather facts, evidence, and experiences and network with one another. Keep putting pressure on politicians. Help expose the CPS kidnapping racket on the internet by streaming videos such as YouTube and other similar websites. If any of you know friendly and honest people in the media, please ask them to help expose the sinister child snatching, human trafficking racket. And please visit our website, www.kitandnancy.com. And that's spelled KITANDNANCY.com. Thank you.